and welcome to Daily News Simplified, the answer to what, why and hows of newspaper reading. Today I am going to discuss Delhi edition dated 1st February 2018 of The Hindu. So let's begin. The first important news appears on page 1, which reads, Budget expected to focus on direct taxes. And this news has also been carried forward on page 10. Now, as we all know that the union budget will be tabled today and there are certain expectations from the upcoming budget. So, one of the most important expectations from budget 2018-19 is pertaining to direct tax reform. Under this, it is expected that the upcoming budget will bring about a change in the income tax slabs, medical reimbursement limit, and the corporate tax rates in the country. However, indirect tax rates are not expected to change under the upcoming budget. As we know, last year the government introduced the goods and services tax, which subsumed all the major indirect taxes in the country, and hence there is not much scope left for any change in the indirect tax rates in the country. The requirement of a change in the direct tax system of the country has also been covered in the December 2017 issue of the Focus magazine. So let's take a look at that. As presented here, the government had set up a task force under Arvind Modi, member of CBDT, to review the Income Tax Act 1961 and draft a new tax law which is in consonance with the economic needs of the country. Now, the need for a direct tax reform in the country arises because there are various problems at present in the direct tax system of the country. Let us discuss them one by one. Firstly, the tax compliance is very low in India. As compared to OECD countries, personal income tax compliance in India is very low. Next, the direct tax system suffers from the problem of tax evasion. That is, poor compliance of direct tax in India has led to massive tax evasion and tax avoidance. It is also caused due to high marginal direct tax rates in the country. Also, direct tax system suffers from the problem of limited coverage. This is because agriculture sector and unorganized sector are outside the ambit of direct tax. Also, direct tax system is full of exemptions. Many exemptions, allowances and deductions are provided under the direct tax, and as a result, they lead to evasion of tax and affect the revenue yield of the government. The next problem is pertaining to tax burden. Since direct tax system suffers from lower compliance and high exemptions, as a result, there is a disproportionate pressure on individual taxpayers and other tax complying individual citizens. Also, direct tax system suffers from many inefficiencies and search and seizure provisions. So after looking at these problems, we understand that a direct tax reform is much needed in the country. Let us wait and watch what is announced in the upcoming budget pertaining to direct taxes. So after understanding the problems facing the direct tax system, we know that there is a requirement for decrease in tax rates in the country. However, this decrease in tax rates should not reduce the government's revenue. This is because if there is a sharp reduction in the government's revenue, then it may exceed its fiscal deficit target. And as we all know, fiscal deficit is the difference between the total expenditure of the government and the total receipts of the government, and tax forms a part of the receipts of the government. So if due to a reduction in the tax rates, the total receipts decline, then in that case the fiscal deficit of the government might increase, which may affect the GDP growth of the country. The other important expectation from this year's union budget is pertaining to agriculture and rural development. As we know that farm distress has been rising in India over the past years. Hence, it is expected that the government will take measures to boost the agriculture and rural development. Let us wait for the budget to be announced to see the exact steps taken by the government to solve these issues. With this, let us move on to the next article. The next important news appears on page 1, which reads, India can't be refugee capital, says the government. And this news has also been carried forward on page 10. This news is pertaining to the issue of Rohingya refugees, and as we all know that Rohingya refugees are trying to enter India and the border guarding forces such as BSF and Assam Rifles are not allowing them to enter. Now, a petition has been filed in the Supreme Court to observe whether the judicial standards of India with regard to refugees is applicable to those refugees who are trying to enter India. At present, the news is sub judice and let us wait for the Supreme Court's verdict on this. But with the help of this article, let us understand the refugee policy of India and the policy of non-refoulement. Firstly, we will talk about India and its legislative policy on refugees. As of now, India does not have a national law on refugees. So with regard to refugees and asylum seekers, the Foreigners Act 1946 is used as a reference. But the most concerning issue with this Foreigners Act 1946 is that it does not contain the term refugees. This act only uses the term foreigners, which may include refugees, asylum seekers, migrants, and tourists. There are some other acts as well which are used as a reference with regard to the entry of refugees, such as the Passport Act 1920, Passport Act 1967, the Foreigners Act 1946, and so on. So, pertaining to the issue of refugees, India formed the Justice P.N. Bhagwati Commission, whose task was to construct a uniform national law on refugees. This commission describes a refugee as any person who is outside his country of origin and is unable to or unwilling to avail himself of the protection of that country because of a well-founded fear of persecution on account of race, religion, sex, ethnic identity, membership of a particular social group or political opinion, or owing to external aggression, occupation, foreign domination, serious violation of human rights or events seriously disrupting public order in part or whole of his country. So till now we have understood that India does not have a national law on refugees. Let us now understand why India does not have a national law on refugees. Firstly, the current arrangement of managing refugees and asylum seekers in India is through ad hoc administrative decisions. And these decisions are based on political and security considerations, which are more convenient. Due to these ad hoc administrative decisions, India does not have any national law on refugees till now. Secondly, having a national law might encourage more refugees to enter India, and this might increase the threat of social, economic, and political insecurity in the country. And thirdly, many migrant laborers from neighboring countries may enter India in search of work and may present themselves as refugees. So because of these three reasons, India has still not adopted any national law on refugees. So after having an understanding about the legislative policy of India on refugees and why India does not have a national law on refugees, let us also quickly understand the policy of non-refoulement. According to the principle of non-refoulement, states are under the obligation to not send back the refugees to their country of origin where they may endure grave violations and persecution of their human rights. So India follows this policy of non-refoulement, and the Rohingya refugees in India are protected under this policy. But the question is that whether this policy of refoulement can be extended to those refugees who are now trying to enter India or not. So let us wait and watch for the verdict of Supreme Court on this. With this, we move on to the next article. The next important news appears on page 7, which reads, INS Karanj boosts Navy's firepower. Now this news is pertaining to the launch of INS Karanj, which is the third state-of-the-art Scorpene submarine of the Indian Navy. So let us quickly understand a few key points about INS Karanj. Firstly, INS Karanj is being built by Mazgaon Dock Shipbuilders Limited, Mumbai, under a $3.75 billion technology partnership with France. Next, we should discuss about some of the features of INS Karanj submarine. This submarine is a Scorpene type submarine, which means that it is a conventional diesel attack submarine. The length of the submarine is 67.5 meters and its weight is 1600 tons. Also, the submarine has 360 battery cells which will be used to power the magnetized propulsion motor. The submarine also has two 1250 megawatt diesel engines for charging batteries. The expected date of commissioning for INS Karanj submarine is in end of 2018. So INS Karanj is being developed under a project which is launching 6 submarines in total. Of these 6 submarines, 3 submarines have already been launched and 3 are in the pipeline. And all these 6 submarines are expected to be commissioned by 2020. So with this article, we have understood about the basic features of INS Karanj submarine, which is important from the prelims exam point of view. With this, let us move on to the next article. The next important article appears on page 8, which reads Power of a Single Identity. This article compares India's Aadhar with America's Social Security Number or SSN. The article begins by saying that how SSN was opposed by USA when it was introduced in the year 1935, and similarly Aadhar is also witnessing the same phenomenon in India. As we know that Aadhar is being opposed on various grounds such as privacy, security, penetration, relation between citizens and states, and so on. And as we know that the case of Aadhar is being argued in the Supreme Court and it will soon decide the fate of Aadhar. In order to deal with the security concerns of Aadhar, the government has taken various steps such as face recognition, 16-digit virtual ID and setting up of B.N. Sri Krishna Commission to make a law on data security. Since we have earlier discussed about SSN, let us understand a few basic features of the SSN or the Social Security Number of USA. So SSN is a 9-digit number which is provided to the citizens as well as non-citizens of USA, and unlike Aadhar, SSN does not include the biometric data of individuals. SSN was established through a Social Security Act of 1935 and its aim was to create a national old age pension system. So one of the basic differences between Aadhar and SSN is that Aadhar has been created to provide identification to citizens, whereas the main aim of SSN is to create an old age pension system. So with the help of this article, we have done a comparative study of India's Aadhar with USA's Social Security Number, and questions pertaining to this may be asked in the prelims exam. With this, we move on to the next article. The next important article appears on page 9, which reads Testing Waters. This topic is pertaining to the interstate river disputes, and interstate river disputes and river linking projects have been asked in the past in mains paper of UPSC exam. That is why this topic becomes very important for us to understand. So in the current setup of Indian democracy, solving of interstate river disputes has become increasingly difficult. This is because there are different political parties operating at the center and state level, and as a result, solving of disputes has become difficult between two different states. Hence, the government decided to resolve these disputes institutionally, and therefore, Article 262 of the Indian Constitution provides for settling of river disputes between states. In this respect, the Government of India had constituted the Interstate River Water Disputes Act 1956. However, now the government has introduced certain fundamental changes in this Act of 1956, and now in 2017 it has introduced the Interstate River Water Disputes Amendment Bill 2017. Let us understand the important provisions of this bill and how is this bill different from the 1956 Act. So now we will discuss the main provisions of the Interstate River Water Disputes Amendment Bill 2017. The first important provision is pertaining to the establishment of Interstate River Water Disputes Tribunal. So earlier, for every river dispute, there was a separate tribunal, but as per the provisions of the new bill, all those earlier tribunals shall be dissolved and any new pending matter of water disputes should be brought to this new River Water Disputes Tribunal, which is a permanent tribunal. Secondly, the bill establishes a disputes resolution committee in order to resolve the disputes amicably. This disputes resolution committee is responsible for solving a water dispute by negotiations in a period of 1 year, and it should submit its report to the central government. This report submitted by the DRC should contain details of the stand taken by each state government, what is the stand taken by the members of DRC, and along with this, all the relevant facts and information pertaining to that particular dispute. Thirdly, the new bill provides for appointment of experts who are serving in the Central Water Engineering Services as assessors for each water dispute. And lastly, the bill provides for the decision of the tribunal to be binding. That is, the decision of the bench of the tribunal shall be final and binding on the parties to the dispute. So till now we have understood about the main provisions of the Interstate River Water Disputes Amendment Bill 2017. Let us also understand how this bill of 2017 is different from the Interstate River Water Dispute Act of 1956. Firstly, the 2017 bill proposes to introduce a mechanism to resolve water disputes amicably through negotiation. However, this mechanism was not available under the 1956 Act. Secondly, the proposed bill of 2017 seeks to provide for a single standing tribunal. This is different from the 1956 Act, which provided for multiple tribunals for multiple disputes. Thirdly, the 2017 bill provides for experts known as assessors who will provide technical support, which will be helpful in adjudication of water disputes. And lastly, the total time period for resolution of a water dispute has been fixed at a maximum of 4.5 years under the 2017 bill. This will help in coming to a solution in a strict and scheduled time frame. Now, a question has been asked in UPSC Mains 2013 exam, which says, constitutional mechanisms to resolve the interstate water disputes have failed to address and solve the problem. Is the failure due to structural or process inadequacy or both? Discuss. So from the above explanation, we can say that the proposed bill of 2017 will help in resolving the interstate water disputes in a better manner, and hence the topic of interstate water disputes is very important from our exam point of view. With this, we move on to the next article. The next important news appears on page 11, which reads Indian Aid for Palestine Diplomatic Institute. So this news talks about PM Modi's visit to Jordan and Palestine, which is scheduled in February 2018. During this visit, India will form an Indo-Palestine Diplomatic Institute, and this institute would impart diplomatic training to Palestinian diplomatic agents and allow for interaction with Indian diplomatic agents. Now from this news, it is important to understand why this visit is significant. Now this visit of the Prime Minister is the first visit to Palestine after India voted in favor of the Palestinian position in the recent United Nations vote. Secondly, this visit showcases India's attempt to de-hyphenate its relations with Israel and Palestine. This de-hyphenation means that India would maintain separate relations with Israel and Palestine, and it should not let the conflict between Israel and Palestine impact India's respective ties with these two nations. This visit also showcases that the Indian PM has visited Israel and Palestine separately and not tied to the reciprocal kind of visit which was practiced earlier. As of now, the news is in transition, and we should wait for the PM's visit to conclude to have a further discussion about this visit. Also, from the mains exam point of view, this de-hyphenating policy of India with Israel and Palestine is very important. With this, we come to an end to today's newspaper discussion. If you wish to interact with the members of Rao's Focus team, you can join Rao's Focus Facebook page, whose link is given in the description box below. Now, let's move on to question for the day.